Hello, my name is Calrie Marsh, and I'm an attorney who practices in the area of bar admission. Previously, I did a video regarding the 5 top issues that applicants face when applying to the Florida bar, and today I want to take a closer look at criminal history. Criminal history is a huge topic for the Florida Board of Bar Examiners because it really goes back into your past conduct and whether or not it indicates how you will behave in the future. Criminal history is covered in items 19 through 23 of the bar application. Let's start with item 19, felonies. Now, just because you've been convicted or charged with a felony does not mean you are ineligible to apply to the Florida bar. However, you have to consider policies in place regarding certain types of felonies, and if you are convicted of a felony, that your civil rights are restored prior to applying to the Florida bar. Under Florida law, if you're a convicted felon, you must have your civil rights restored before you can apply to the Florida bar. In the years of practice, I've seen applicants who went to school or lived in other states where they were convicted of a felony and there was no process for restoring rights, but there was some court document or state document to indicate that they have the ability to vote and to carry on as any other citizen. And therefore, this would be acceptable to the Florida Board of Bar Examiners. Also, juvenile felonies. Now, juvenile records in Florida in most states are sealed, confidential per statute. And in order to provide those records to the board, you may need to do a motion to unseal or go to the courthouse yourself to get those records sent directly to the Florida Board of Bar Examiners. When it comes to felonies, you have to look at what the charge is, what you were convicted of, and whether it meets the eligibility standards for application to the Florida bar. Question 19 of the Florida bar application doesn't limit disclosure to just convictions or charges. It also includes if you've been charged with a felony and then it was reduced to a misdemeanor, if you've been informally or formally charged, but it didn't lead to a conviction, if you were arrested or detained or restrained for felony conduct. If there's anything in your record that says felony, mentions felony, that's something that you must disclose under item 19, even if it was ultimately dismissed or adjudicated as a misdemeanor. A lot of times applicants get tripped up with this question and omit or put information in the wrong place, which can lead to issues with the application. Misdemeanors. Misdemeanors are crimes that are usually of a lower level and can include traffic infractions, lesser degree crimes, but they can also include violation of ordinances. And so when you look at what should be disclosed, look at citations and notice to appear. They may say misdemeanors on them or they may not. And sometimes you have to actually go to the statute and look it up to make sure that what you've been cited with or charged with is not viewed or is not deemed a misdemeanor. Misdemeanors are covered under item 20 of the bar application. And sometimes people don't remember, for example, that they were cited for not properly disposing of trash. People are cited for not vaccinating dogs or registering dogs. Certain city or county ordinances, things that you don't think of as misdemeanors but are violation of ordinances. Because item 20 does include the violation of ordinances, not just anything that says this is a misdemeanor charge or a misdemeanor arrest. And so you have to pay close attention to all aspects of any citation received from a state, county, local government when you're completing your bar application. Traffic infractions. Traffic infractions are covered mostly under items 21 and 22. Now, traffic infractions will include DUIs, reckless driving, speeding, failure to have insurance on your car, failure to renew registration, driving with a suspended license. And the one thing that I see often with answering questions 21 and 22, especially 22A and B, is that applicants often do not consider that if you get a traffic ticket, you're pulled over by a police officer, you're issued a citation, and you don't pay it on time, or you don't tend to it in a timely manner, paying the fine or mounting a defense, this citation becomes delinquent. And oftentimes you get what's called a D6 suspension of your driver's license. Now, this is an administrative suspension of your driver's license. So you could be driving around town for a month, 6 months, a year, years, without even realizing that you have a suspended license. And this happens often when people move, or they have different addresses, or you live in a household where there are a lot of people and your mail gets tossed in the corner, or something happens where you're not notified. And the Board of Bar Examiners is very strict on the fact that you say you're not notified, but constructively you are. And if you're in law school, you know what constructive notice means. And this is an instance where constructive notice is going to be used against you or may weigh against you. So when you're completing your bar application, go to the Clerk of Court's websites in all of the cities that you've lived and see if there's anything pending on your driver's license. Pull a full DMV history, a 10-year history, because the DMV, they have shorter history reports that leave things off or don't include certain infractions from previous years. But check to see if your license has ever been suspended. And you would have to answer yes to any of these questions, even if the ticket falls under $200 or it wasn't in the past 3 years, which is 22B. So when you're reading these questions, please read them carefully and make sure you do a thorough job researching and finding information regarding your tickets. Don't take for granted that it was a citation for insurance, it was $145, it was 5 years ago, so I don't need to disclose it. If your driver's license was suspended as a result of failure to pay that fine timely, then you will need to disclose that information. Finally, some resources for checking your criminal background that you should be mindful of. I've mentioned the Clerk of Court's website, so if you live in another state other than Florida, go to that local police department, request records from the local police departments for arrest records, incident records, anything that has your name attached to your date of birth. Do a record search. And if nothing comes back, then great. You don't have to disclose anything, but check if you even doubt or have some suspicion that you may have received a citation or the police were involved in an incident with your name on it. Online Clerk of Court services is also another way for you to check and verify information. And this is relatively easy to do. Most Clerk of Courts has an online case search. If they don't, then you can also do a paper request, and they can provide the records via mail. Of course, you're paying for postage and usually copy charges, and it may be a longer process, but again, you need to take the time to investigate and make sure you have the most accurate information. In Florida and other states have similar organizations. You can do an FDLE background check results, and FDLE stands for Florida Department of Law Enforcement. And most states have one organization or one state agency that sort of houses all of this information, because this is where the Board of Bar Examiners is going to get their information from as well. You also have online public background search services that you may utilize and pay a fee for them to give you background information. I'd recommend, if you're going to use one of these services, that you also do your own due diligence, because in my experience, some of these services fall short of bringing back information that's relevant to your background, to your criminal history. And if you rely solely on that and the board finds something that's not on that report, then you are going to be in a position where you're held accountable. And you can't say, well, I used the service and I paid money and they're supposed to be accurate. That's not going to fly. So make sure you cross-check and do your due diligence. One other agency other than police departments is campus security. Campus security can be considered as para-police, and across the United States, in small towns or small counties where there's a college campus, the local police is campus security. And so it's helpful to search campus security if you've ever had an incident on the dorms, or you've ever been written up for possession of illicit drugs, or if you've ever had a violent encounter with another student. Anything of that sort where a police or campus police was involved, that could be part of the public record and something that the board searches for as well. So it's not something that people think of often, but I have seen instances where not finding that report or not submitting that information turns into a lot of questions from the Board of Bar Examiners. I'm not saying it will stop you from becoming a lawyer. I'm not saying it will prevent admission, but it may delay admission. It may make things tougher for you during the process. So the takeaway is, know before you apply. Get your information, get accurate information from reliable sources before you file your application. I hope that this video has been helpful. Hit the subscribe button, like, and share this information with your fellow law students.